All right, welcome to the Long COVID and Post-Infectious Syndromes Echo, a collaborative effort between the University of Utah and Bateman Horne Center. I'm Clayton Powers, Doctor of Physical Therapy and Director of Education at Bateman Horne Center, and I'm joined by Sarah Day, Project Echo Lead at University of Utah. Today's session is being recorded, but any participant details or sensitive information will be removed before it's shared on the website or social media. After the session, Sarah Day will email CME instructions and a copy of the slide deck. And please note that CME credit can take, it has to be claimed by midnight tonight, and it can take up to 24 hours to appear on your CME profile. We invite all of you to introduce yourself in the chat and use the chat to ask questions or make comments. We also want to remind everyone that this is a clinician-only forum, so we try to stay professionally focused. If you missed a session, you can find the recordings and slides at the University of Utah's Echo page or Bateman Horne Center's YouTube channel. Today, we're privileged to have Edward Dabdoub from Dabdoub Law Firm speaking about navigating the disability process with long COVID and ME/CFS. So thank you so much for being willing to talk to us today. And go ahead and introduce yourself and share your slides. The time is yours.
All right. Thank you, Clayton, for the introduction. I appreciate it, and I'm delighted to be here. We've already had our first win. Clayton pronounced my last name perfectly, and that's not something that happens often. Today, well, before I talk about what we're going to discuss today, allow me to introduce myself. I've been practicing as a disability insurance only attorney representing plaintiffs. So folks like your patients, people across the country who are too sick or who are injured to continue working. And so for the last 20 years, I've specialized in this practice area. I started off actually in law school as a law clerk for a firm doing this work, fell in love with it, really got addicted to the feeling of helping people and just the immense gratitude that your patients, our clients show when we get their benefits approved. It's life-changing for many of them. And so after law school, I moved on to a firm that also specialized in this practice area. It was a very small firm. And then after being there about 2 years, I started my own firm, and it's been about 17, 18 years of building a firm. Not just any firm, but we take great pride in doing this work nationally, and we really have fine-tuned our craft, and we're at a point now where the overwhelming majority of our clients end up getting paid, and our goal is to keep them out of courts and the stress of litigating these cases and just trying to have the process run as seamless as possible. That's not always easy when you're dealing with a for-profit insurance company. But we've made great strides, as have everyone here in this session today on the medical side. I don't think we're in the same place where we were all 20 years ago. Of course, we now had a pandemic and long COVID had emerged, and we've grappled with the issues that we faced there. But we learned a lot from ME/CFS going back 20 years or even before that. And so where things stand now, as far as the insurance companies go and federal judges in court, things are a little bit different when it comes to ME/CFS and now with long COVID. I do think the onset of the pandemic and then long COVID has changed things on the legal side for the better, because I think everybody experienced the pandemic in a very real way, either directly because they themselves became sick or they know a loved one who struggled with long COVID after the fact. So just the pervasive nature of that disease, I think, has influenced the thought process on these conditions more generally in a way that has been favorable to us on the legal side. So today, with that introduction, I want to then touch upon
Great.
All right, so that's the start. And okay, so we're going to discuss the disability process, how to navigate that, specifically with long COVID and ME/CFS in mind. And here we have disclaimers. Clayton, do you want me to read through these?
No, you can just click through them.
Okay. All right. The objective. All right. What is it that we are going to discuss? Right. So we're going to talk about some of the common issues in ME/CFS and long COVID disability insurance claims, right? What is it that we're seeing on the legal side? And how can treating providers help? Because the reality is that on the legal side, there's only so much we can do. There is a lot that depends on the treating providers. And I want to kind of discuss that, and I'm hoping that it will shed some light on some of the small things that could be done on your side that could make a massive difference to your patients and our clients. First, a brief overview on how disability insurance works. And I'm speaking specifically about long-term disability insurance. And when we say long-term disability insurance, we're talking about insurance companies, which is different than an application for disability benefits with the Social Security Administration. So in this context today, we're discussing private disability insurance, long-term disability with insurance companies. And it always begins with submitting an initial claim. And that submission, that initial claim packet ordinarily includes the medical records for the patient. The patient has to complete a claimant form and then an attending physician statement. When all those three things are received, the insurance company begins the review process. And I'm not going to get into too much detail, but the insurance company does have deadlines by which they have to make claims decisions. And they don't always abide by those deadlines. And instead, they like to blame the claimant for not completing the paperwork on time and not submitting anything. So just straight away, one of the easiest things to do to get the process started is to complete those physician statements and not afford the insurance company an opportunity to delay payment. The delay and deny tactic is what insurance companies do across the board. Now, if the initial claim is denied, then almost always the law requires that the patient submit an appeal back to the insurance company. This appeal becomes the single best opportunity to avoid a lawsuit and get the claim paid. We're going to discuss how that can happen in a bit. I started off by saying I think we're in a better place today than we were 20 years ago, and I truly believe that. When I started practicing, the major hurdle was convincing insurance companies, convincing their doctors, and indeed convincing some federal judges that ME/CFS was actually a legitimate medical condition. And so I'm sure all of you have shared that experience, even within the medical community. And from my perspective, anybody that holds those views today are really kind of odd outliers that really don't merit much engagement. So that's not really the fight we see now. What we see is the dispute being whether the patient is functionally incapable of sustaining full-time work. And that's where the focus to the insurance companies have shifted, right? So now what they've done is they've gotten a team of doctors whose goals are to write reports explaining that the person is still capable of working. We'll talk about how they do that. So just a few common issues, broad strokes here that we see with ME/CFS and long COVID disability claims. Disability insurance policies have limitations. And by limitations, I mean the insurance policies are designed generally to pay benefits as long as someone is disabled, usually through age 65, 66, age 67, through retirement age. But the insurance companies have written in limitations into their insurance policies for medical conditions they really do not like. And broadly, those are conditions that are primarily based on a mental health condition or based on chronic fatigue in some way. And so we've seen over the years more and more limitations are being written in that are now explicitly targeting ME/CFS and long COVID as conditions that are only going to be paid for a maximum of 24 months. And that's another way the insurance companies are trying to limit their liability as they shift away from denying the existence of a condition to challenging whether the condition is disabling enough. Okay. And limiting payment through the 24-month limitation. The second issue that arises in the legal side of things is the insurance companies love to argue that the symptoms are inherently subjective. And yes, a lot of the symptoms are subjective, but they do not take a more holistic approach in looking at the claimant. And instead, they're just kind of myopically focusing on what they view as a lack of physical examination findings, etc. And so we've had to litigate some of those issues. But the good news is I think the federal courts, the judges are waking up to this tactic of just kind of broadly saying, well, your symptoms are subjective primarily, and therefore we can't believe that you're disabled. So a lot of progress has been made on that front. Now, the third, many treating doctors across the country, they just don't have expertise in ME/CFS, long COVID, and they also struggle with really understanding how that claims process works. And I think the insurance companies could do a better job in explaining to the claimant, your patients, on what needs to be done. But certainly they're not going out of their way to help them get their benefits approved. So often clients come to us and sometimes it's just something simple that needed to happen, and the insurance company just needed to tap them on the shoulder and say, hey, just, can you do this? And we should be able to move this forward. And they don't. They just lay in the weeds and they stay quiet. And I suspect over the years, what we've seen is that is done by design to frustrate the process. When someone's struggling, as you very well know, with these conditions, the added stress makes things so much worse. And the insurance companies would love nothing more than the person to just give up and walk away. Last, the insurance companies do not understand ME/CFS or long COVID. That's not 100% true today as it used to be. I think they understand it a whole lot more than they used to. They understand it well enough to know they shouldn't get an ME/CFS or long COVID expert to review a disability claim, right? What we see is that they're still going to physicians who do not have the requisite experience, training, or knowledge to make a determination of disability. So it's almost like they're willfully closing their eyes and going to doctors who just are not equipped to manage this, or will sing any tune money will buy. And unfortunately, there are some doctors out there that are on the insurance side of things that will continue to write these reports to shoot down claims. Now, most disability claims are governed by a federal statute called ERISA. ERISA stands for Employee Retirement Income Security Act. Without getting into the details, I will share that when ERISA was passed in 1974, the stated intent was very good. The statute was passed with the purpose of protecting working class Americans' benefits in the event of disability, among other sorts of benefits. But what we've seen over the last 40 odd years is the federal courts have kind of evolved to become a little bit hostile to our clients And so the case law in court has developed in a way where it's far more favorable to the insurance companies. And here's some examples. In a normal type of case, if you sue an insurance company, you are permitted as the attorney, the plaintiff, your patient is permitted to introduce any medical evidence or non-medical evidence that helps to prove that they are disabled, right? The only question is this piece of information or document relevant to the question of whether they're disabled or not? And if it is, it's introduced ordinarily, right? But when it's an ERISA governed case, it's not. What instead happens is when you are going through the initial claims and appeals process with the insurance company before a lawsuit, the insurance company is compiling all the documents and records that you are submitting and putting it into an insurance company claim file. When the insurance company denies your patient's appeal, the claim file closes. And so the next step would be a lawsuit. The problem is that your patient is not allowed to introduce any new information into their case at that point. And this is important for you to know because your ability to help your patient is truly only going to occur during the claims process or if they have an appeal. Once the appeal is denied, in most situations, you're not going to be able to write letters. You're not going to be able to complete questionnaires or physician statements. It would be too late to get that information in front of the insurance company. And in an ERISA case, the other thing you're not going to be able to do in most cases is to testify or even to be involved in a deposition. So I like to tell my clients, tell your doctor that the best and only chance they can help is during the claims and appeals process. Once that process is over, they will have no role to play in your case, and they would not be part of a lawsuit. Second, no jury trial. My goodness, we're in the United States. There's a Seventh Amendment right to a jury trial, except if you're suing an insurance company for disability benefits. In most cases, you do not have a right to a jury trial. And the problem with that is the federal judge is going to be making a decision on your patient's case based on cold pieces of paper. The human element, looking at that person, having a jury weigh the credibility of your client in a courtroom is not going to happen. And so this is one of the benefits that we see insurance companies kind of hiding behind, right? That they don't have to face that person in court where a jury made up of their peers is going to look at your patient and say, do I believe this person? Do I believe their doctors? Do I believe all the people that have come up here and testified in court that he or she is disabled? Third, no punitive damages, right? So what does that mean? Well, it means if the insurance company really deliberately targets your patient's claim for denial, forces that person into a lawsuit, and they end up losing that lawsuit, well, they're no worse off than they were before. All the insurance company has to do is to pay the benefits they owed in the first place. So this creates a massive disincentive for the insurance companies to do the right thing in the first place. Last, the standard of review. The standard of review in most cases is whether somebody is disabled. Does the evidence prove that they're disabled? And if the answer is yes, they should be paid. They win their case. But in an ERISA disability case, right, long-term disability we've been speaking about, the question is, in most of these cases, whether the insurance company's decision to deny benefits to Miss Mary Jane, for example, was it reasonable? And if it was reasonable, your client, my client, your patient loses, even if the judge agrees that the person is disabled. So it's a very difficult standard to overcome because the insurance companies are going to be generating written reports by their internal doctors and sometimes outside doctors with the purposes of showing that the person can work. So no, in the end, in most of these cases, you have conflicting medical opinions. You have the opinions coming from folks like you who are supporting your patient's disability. And then you have reports generated by the insurance companies, doctors who said they're not disabled. And when you have these conflicting medical opinions, the judges almost always say, well, the insurance company might have been wrong, but they were not unreasonable. And so we see judges don't want to supplant the medical judgment of other doctors, and they're instead looking to see if there's conflict. And if there's conflict, they just say it can't be unreasonable. And that's what so you put all these four factors together, and the reality is you end up with a situation that has created an incentive for insurance company to behave badly. And in that context, then they start to target ME/CFS, long COVID disability claims more than perhaps other medical conditions. Here's a few examples just to kind of put a visual on what some of these denial rationales look like. Now, when we get letters from insurance companies denying a claim or denying an appeal, the letters could be anywhere from 3, 4, 5, 7 pages long. But here's a snapshot, right? Essentially, what they are saying in the first one is that they're limited examination and diagnostic findings, right? So, and that by itself is good enough for them not to find somebody could be disabled, right? In the second example, examinations by other providers did not identify physical findings that would preclude sedentary activities, right? And then they go on to give some kind of examples. And then the last, in regards to cognitive impairments, this says examinations did not support cognitive deficits. So it's just by the insurance companies in looking at your medical records for what's not there, rather than looking at it holistically for what is there. It's the proverbial cherry picking that we've seen in insurance companies do. And there are ways to defeat it. We're going to talk about that. Okay, so I'm going to skip this slide because we went over the limitations. This is just mentioning that for certain conditions, payments are limited to 24 months. But I'll add to that one thing. More recently, since the pandemic, more and more insurance policies are being written now to explicitly limit long COVID and ME/CFS to only 24 months. Sometimes they'll use a broad stroke of any medical condition based primarily on chronic fatigue. But now we're seeing that they're really starting to target some of these conditions in a precise way. And I think part of that shift has to do with, as we get stronger on the legal side and medical side and start to come forward with stronger and clearer arguments and better evidence of disability, medical and otherwise, there's always this adjustment that's happening on the other side with the insurance companies. And this is just the latest iteration of that. All right, so how can you help? Brilliant. I love having these conversations, right? On how a physician or a practitioner can help, right? It's not good enough. It's the biggest mistake to think that just getting a diagnosis out there is going to be like a silver bullet. It's not. You have to tie the diagnosis, first of all, to the diagnostic criteria. I have some practitioners who will write letters for me, and I know it's going to be brilliant because they have in all their letters the diagnostic criteria. Take the diagnostic criteria for ME/CFS, for example. They lay it out. Okay, I know it. You know it. The insurance companies know it. But put it on paper. Cut and paste it into a letter. And then walk through why the person meets each one of those requirements. It completely changes the weight that should be afforded to a letter like that. Right? And I'm speaking from the perspective of being in front of federal judges and judges holding a letter like that and asking the defense attorney, the insurance company's attorney, explain why this wasn't good enough. Okay. Now you juxtapose that letter with a letter that just basically says, person can't work, diagnosed with long COVID. But without more, those letters are not going to be given weight. Yeah. You're experts, and we appreciate that. But the insurance companies and the courts are not giving a lot of weight to letters from anybody, no matter their expertise in the condition, if you don't put some meat on the bones. And I want to be clear, I think, to be fair, no, we don't expect practitioners to write 7-page letters, and I don't think that's necessary. Some of the best letters are 3-4 paragraphs long, not a lot. And a lot of them, we could even share some templates where the first half of it is templated with the diagnostic criteria, and then you just plug in certain information after that. Massive difference. That just makes a world of a difference. So the other thing is bullet point 3, right? The post-exertional malaise, right? That's like the telltale sign. I would spend a little time on that, right? The patient gets fatigue after exertion, physical or mental. It's just never going to be good enough. The best types of evidence are those that give you just a little bit of a human touch, right? Like the letter that says, a patient reported she attempted to walk her dog, but couldn't. And then what happened after that? How did her body respond to that for the next 2-3 days? Putting that information in the letter really makes a difference. Then quantify restrictions and limitations. This is where the fight comes in. Okay? The insurance company's doctors are going to broadly always state the patient can sit throughout the day, because sitting is sedentary. So who can't sit and work, right? Well, my clients can't. Many of your patients can't. But why? And how long? We got to explain that, right? Can they sit only 6 hours in an 8-hour workday? Well, that's barely enough to not be disabled. Anything under 6 hours in an 8-hour workday constitutes disability. So we want to document it. We want to be able to show our clients cannot sit for maybe more than 5 hours in an 8-hour workday. Standing, right, and walking, we want to get those limitations written down. How about lifting, if you have that information? And then this one is hugely important to me. How many naps are required a day, right? Because last time I checked, you can't interview for a full-time job and ask the employer how many naps a day can you take, right? So if you're documenting how many naps a patient has to be taken a day to just be able to barely get through their activities of daily living, if they could even do that, that speaks volumes to their inability to sustain full-time employment. All right, documented failed treatments, those are helpful. Those are typically seen in medical records. One area I would love a little improvement on in some of my clients' records is the observations that practitioners make during the appointments, right? If there could be some description that helps us to get a visual of what they look like in any given appointment. If they show up in an appointment and they're just not looking well, what does that mean? What are the words we could use to describe not looking well today, right? Small things like that corroborate what the insurance companies call their subjective complaints. Well, how is it still subjective if our practitioners are witnessing it and writing it down? It becomes harder and harder for the insurance company to just wholesale sweep it under the rug as these are self-reported. All right. So we spoke about the appeals process being the last and perhaps best opportunity to get your patients, my clients' benefits approved and to avoid the stress of litigation. I'll tell you, at the firm, we've designed a legal strategy specific for these two conditions. We've had roundtable meetings. We're all 10 attorneys in this office for weeks. We just sat around the round table and we just brainstormed. What are we going to do with these conditions? How do we start winning these? And we've come up with strategy that we've been using now since the pandemic struck. And knock on wood, we've not lost a case yet. And we're continuing to use it. We're continuing to improve it. And by working closely with our clients' practitioners, I just don't see how insurance companies are going to avoid paying them. And so far, it's been working out brilliantly. So let's talk about just a few of the things, right? So we have to submit an appeal to the insurance company. Okay, great. We're going to write out our legal arguments, yes. But what is it that is being accompanied with the appeal? What is the medical and non-medical evidence I am going to give them to persuade them to pay my client? Not because insurance companies all of a sudden became good and wants to do the right thing, and I feel they do that sometimes, right? But because it is in their best interest, it's in the insurance company's best interest to look at my client's case and say, not this one. This one was worked up in a way where we cannot win against this person. We therefore should pay this person and avoid the additional costs of ending up in court and losing. So that's a starting point. We have to change the calculus of the insurance company by them looking at your patient's situation and saying, there are many other people out there whose claims we can not pay. This isn't one of them. It's not worth it. Okay. So what that means essentially is at the end of the day, the appeal that we submit must have substantial, in fact, it must have overwhelming evidence of disability, that when the insurance company gets it, they look at it and they immediately realize this isn't a close call. We can't just crank out a denial letter based on a report by a doctor that says her medical records are all just chock full of self-reports and her disability is primarily subjective in nature. Let's just dismiss it. Not happening with this one. So what does that look like, right? So the starting point, we need brilliant letters and questionnaires from treating physicians. Don't need to be 6-7 pages. It's not the quantity, it's the quality of what's put into those letters, right? And we spoke about some of that earlier, diagnostic criteria, observations during visits, what treatments work, why were certain conditions ruled out, right? How did you arrive at the diagnostic? How is it impacting this person's functionality on a day-to-day basis? What are the restrictions and limitations vis-a-vis standing, sitting, walking? That is the core of the evidence that we need to really get our fingers into and win these cases, right? So now, when we get that, the next thing we do is we don't stop there because it's not a close call yet. It's getting to be a really good case, but it's still a little bit of a close call as far as the insurance company is concerned, right? So we then know, to the extent our clients can do this, we like to have them undergo CPET testing. Okay? I will tell you, I'm not a medical expert, but from my understanding, it's not perfect. But this is what we have to work with. And what I like about it is I get to bring a report forward that's based on some functional testing that the federal judges seem to love it. And I tell you, they don't understand it. They maybe read the report and they don't fully understand what it's saying. But the mere fact that there is a cardiopulmonary exercise testing done, we are getting judges to write legal opinions that are saying this is a gold star for disability in the vis-a-vis these medical conditions. So judges want it, let's do it. CPET. Okay, if there's a cognitive component, we'd like to have ideally our clients undergo neuropsychological evaluation so we can identify the areas of cognitive decline. We can get a good report that articulates how that would impact the person's ability to sustain full-time employment. So now we're at a point where we have medical records, letters, questionnaires, a CPET report, a neuropsych report, and then we would also get an independent medical examination. And all these reports, these tests, the CPETs, etc., everything I'm discussing is being done by practitioners who are very qualified in the field, right? And so we're now using qualified practitioners versus the insurance companies are not using qualified practitioners. And that creates a dynamic where the quality of our reports and records are superior. And lastly, we get all of this and we submit it to a peer review physician, again, a qualified expert, right? And the peer review ties all these pieces together and answers the ultimate question for us. Is this person, our client, able to work on a full-time basis in a consistent and reliable manner? Explain. And that's all. And then we get a good explanation that ties all this evidence together. Now, the last thing that we like to do is on the non-medical side, is one must never forget the human factor here. Every client I have ever represented comes to me with a human story. Okay? Whether they have a 2-year-old and a 5-year-old, how is that impacting their responsibility as a mother, a wife, or a father, right? What has happened to them when they've lost their jobs? They've lost their ability to take care of themselves. Some of our clients end up in divorce because it puts this stress on their partners. Everybody here with me today has heard these stories from your patients, my client. My job, my team's job is to get that story in writing. And so we listen to our clients, and we write out a declaration where we give them a voice. And that can be 7, 8 pages long. And man, some of the things I hear from our clients are so moving that any reasonable person who reads what they have gone through in their voice, bearing in mind all the evidence that we are submitting, cannot reasonably conclude this person is faking or exaggerating. And that's where we end up taking the case. I'll give you one quick example. We won a case for a lady. She was in her mid-20s, long COVID. Started her career. She was doing really well, high income earner. Very active, very physical. And after developing long COVID, she just wasn't doing well. She ended up in a wheelchair. We have photos of her wearing her wedding dress in a wheelchair. And we've all seen these photos, right? Maybe those of us who are married have photos of, everybody's gathered around the bride and the groom, and there's this photo. Bride looks stunning, groom looks sharp. Well, she looked beautiful, but she was in a wheelchair. And she had her family around. Other than being in a wheelchair, it was an ordinary wedding photo. And one has to ask, well, would she really do all of that just to fake a disability case? And that's the kind of rhetorical questions I put in front of the insurance companies and the judges. So is this part of the scam, this photo that she's put together? And then all these reports, and how about the letters from her practitioners who are experts in the field? Is this all part of like some massive scam to defraud an insurance company? Or could it just possibly be that she is truly disabled from long COVID? That's not a close call. I'm going to leave it there because I think I threw a lot of medical, well, not so much medical, a lot of legal information your way, and I would love to open it up. Clayton, I'd love to open it up to questions.
I wanted to first see if Todd Davenport, who's on the call, would be willing to touch on CPET testing. Well, cardiopulmonary exercise testing. Workwell Foundation does a lot of those disability applications, and just want to see if you had any thoughts about or experience with doing those applications, and then have Dr. Bateman comment on the cognitive testing they do with the NASA Lean, and then we'll get into the questions.
Yeah, thank you for the chance to comment, and thank you, Eddie, for a really great talk. I really appreciated it. As Clayton mentioned, the Workwell Foundation out here in California has been involved in cardiopulmonary exercise testing for medical legal purposes for maybe about the past 20 years. And a lot of the experience that you've heard in terms of being able to objectify disability using, and I'm not a lawyer, so no legal advice here. Obviously, you have qualified folks to do that. I'm just an academic, so I like to argue. That's very different than being able to provide legal advice. But I do know that CPET is admissible evidence for, specifically laid out in the Social Security Administration documentation. I want to say Chapter 6 or thereabouts, but I haven't seen the updated version. So it is nice to have that objective characterization of a person's function that can be indexed very easily onto their daily activities. There's some shortfalls of it, of course. One of which is the post exertional recovery, which actually turns out to be a very important piece to document because most people should be able to do 2 days of cardiopulmonary exercise testing in a row without significant functional decrement beyond about 24 to 48 hours. And we frequently will see much more prolonged and abnormal recovery periods following CPET. And then the other piece is just being able to take some of the numbers from CPET and associate them with the values for the metabolic values for average daily activities. But we don't really get into the cognitive piece, which I know Dr. Bateman is going to talk a little bit more about here in a moment. But thanks, Clayton, for the chance just to add that additional information.
Yeah, no problem. I think it's really helpful to understand these different options and then to share that story because they aren't going to understand the CPET, but the story behind it and what it means. Dr. Bateman, do you want to comment on CPET or cognitive testing? I know with the NASA Lean test, you also do the Dana Brain Vital test to capture some of those objective measures for
Yes,
disability.
happy to. One of the things we've tried to do at Bateman Horne Center is to provide tools that are accessible to every clinician. And I want to talk a bit first a little bit about dysautonomia, orthostatic intolerance, and POTS. These are illnesses that can be documented objectively. And of course, the gold standard is tilt table testing. But as early as like 2015, we started doing lean testing or passive stand test as part of a CDC study to understand orthostatic intolerance. And very quickly, I realized that would be a valuable tool in our clinic. So we started doing it in every patient. So we would understand and have that objective data in the chart. And I'll just put in a little plug for the NASA Lean test. NASA Lean test is just one way to do orthostatic testing, but it's a standardized test. That means we teach people how to do it the same every time. So the results are repeatable and comparable. So I usually in my applications talk about the findings on the NASA Lean test. And of course, it's really important to include physical signs, like when you can see people's hands get white or their feet get purple, and to document the symptoms that are occurring because those are important for making the diagnosis. It's really helpful if someone has faints or can't make it through the test, but even if they don't, and it's those people that don't pass out or necessarily have a disaster from the testing or not able to finish that made us want to start looking at cognitive impairment. So we just, and I'm not sure this is the gold standard or everybody has to use it, but we purchased something called Dana Vital testing. And what we did was these cognitive tests, these very brief cognitive tests before the lean test and then immediately after the lean test. And we're able to show that the reduced perfusion during the upright orthostatic stress altered and reduced the ability for people to think clearly. Sometimes you can see this clinically, and if you are doing the lean test and your patient is dazed and can't answer questions after the lean test, the least you could do is write that in the chart, right? And talk about your observations. And observations about physical exam in the chart are also very important. Anything you can come up with that looks different than abnormal because it shows you're attentive and documenting.
Thank you. That's super helpful. There's always the weighing the balance between doing a test that can show something and then also the consequences of that. I've seen some for someone's disability case, I saw one of my patients had a functional capacity evaluation one day and then a second day. And it was so much, it was like 30 minutes of walking plus grip testing plus all of these other tasks that would be way more likely to cause someone consequences is what, like 6 hours for each one, versus doing these shorter evaluations that could still paint the picture for the judge. Or yeah, so it's always weighing that. Oh yeah, Dr. Bateman.
I'll just add that I'm not sure, and we can ask Edward about this, but we used to be required to do functional capacity evaluations. And they're discouraged in this situation because of the delayed consequences of post-exertional malaise and because they don't show what the problem is. And I had a patient once that diligently went through 2 days of functional capacity exams because if you don't give it your best effort, they say you're malingering and not trying. And she was literally bedridden, unable to get out of bed to make her own food the next day. And it took her 4 to 5 weeks to get back to her prior baseline from that extended effort she did for 6 hours, 2 days in a row. So, but being able to describe the consequence of activity, right, in your notes is super important. Here's what happens when the patient does this. Here's what happens when they're upright too long. Here's what happens when they walk too far, or if they get overheated, right? Or if they do too much cognitive work. And being able to document that in your notes has usually been very helpful.
Thank you. Yeah, it's actually pretty interesting to see how I had a patient who said, the judge looked at all my paperwork and said, I don't know what to do with this 1,000 pages of information, but this letter that your physical therapist wrote gives me a good picture, and so I'm going to approve you. And so sometimes it's interesting to see the subjective nature of how they approve some people. Jennifer, and then we'll have Edward answer some questions.
I just also wanted to add that I found with some letters and responses to the letters to lay out a progression of symptoms. And so repeating the Nasoline test, repeating the Dana Brain Vital cognitive testing like a year later or 2 years later, getting regular, maybe even every visit, questions about what their function is, how many hours of upright activity, what happens on their good days, what happens on their bad days. And because you can oftentimes see a progression of worsening condition, unfortunately. Or you can see a consistency of remaining in the same condition. So it provides that consistency. So I think it's important to sort of create that, to lay out that story that's happening over the multiple visits that you're seeing them. And I have had one judge say to me, he kind of coached me without telling me what he needed to hear, and it was those observations in the visit. Just like you said, Edward, is that he wanted to hear me say she looked fatigued, her eyes were closing, she was slumping down in the chair, she was, he wanted to hear me say that, and I had it written in the note, but I didn't clarify it as much as I needed to in the letter. And I honestly think that was the one thing that actually got her disability, was that statement.
Thank you for those insights. Edward, we have a question about those. If the doctor's only got 15 minutes for that appointment, can they give a questionnaire or something that captures some of that information that they can put in a letter?
Yeah, we've designed a questionnaire that we think does exactly that. And it has all the necessary information in there.
Great. Yeah. So just having someone fill that out, and then it sounds like from what you said, you still have to kind of paint the picture, even if you have questionnaires and things, you paint the picture and tell the story about the person, and that helps make it more personable.
Yeah, correct. That's just part of the puzzle. There's a lot more that goes into it. And if I could just briefly mention what Dr. Bateman and Jennifer Bell had touched upon, I think those points were well received, right? I think the FCE is probably better suited for someone with chronic pain, and you have to follow through after the functional testing. 2 days of testing is probably better. I think in the context of the conditions we're discussing today, a CPET is much better. 2-day CPET if possible, and then it's also following through after. So we opt for CPETs instead of FCEs, and then Jennifer touched on the longitudinal evidence, which I find to be very persuasive when you start, because it allows you to connect the dots. And often what happens is there is such an overwhelming feeling, I think, from the judges or even insurance companies, maybe, when you have so much medical evidence and records, that we don't lift our heads out to the weeds and just look at this from 30,000 feet and try to have more of a broader visual of what's happening to the patient. And I think the longitudinal evidence that Jennifer mentioned helps you to connect those dots in a broader way than getting stuck in the weeds.
That makes sense. Do you know if sharing your credentials in treating this patient population has any weight? Like saying, I've treated thousands of patients with these conditions, or like, for example, Bateman Horne Center saying, we've treated these patients, we've done all this research or other things. Does that have any weight, or is it more just the particular case, the patient, more than the credentials of the provider writing the letter?
Yeah, one of the things, it's a great question. One of the things that we do when we're arguing the cases is we validate some of the concerns a judge might have, right? We understand that there's a lot being thrown at you right now, and you are getting conflicting reports from the practitioner side and from an insurance company side. And that may get overwhelming and confusing. But we should take a step back and look at what is the information that you're actually receiving and who is it coming from. On our side, we have practitioners who are truly experts, who've devoted their life's work to this. And so when you have the CVs in the file or the credentials laid out in a letter that you can point to, and then you juxtapose it to the absence of that on the insurance company's doctor's side, for a judge, what you're speaking to is, in their language, is what weight should I give these conflicting reports? Well, as a judge, I'm trained, I should give more weight to the more credible reports. And the more credible reports would be those coming from the practitioners who have been doing this 20, 30 years, or who this is the only thing they do, this is their focus, versus the insurance company whose doctors review every medical condition under the sun and doesn't really see patients anymore. So we get the CVs from the doctors that will perform independent medical examinations, peer reviews, etc. And a lot of the folks here today, we grab the bios or things from online, and we print it and put it in the file, so that it can become part of the record in front of the court if it gets there. So the short answer, no, is absolutely do that.
Okay, thank you. Another question: when should a patient start thinking about applying for disability? Should they start early and get the process going if they think they might need to?
Yeah, so long-term disability follows short-term disability. So you start off with short-term disability, which usually pays the first 6 months somebody's out of work. And almost always the insurance companies, they're happy to pay short-term disability benefits, but then they fight long-term disability claims, because especially with long COVID and ME/CFS, they, as far as I think, they don't share this with us. It's sensitive data that they keep, but I think they have their actuaries run mortality and morbidity tables on this, and I think they view these conditions as disabling conditions that are going to be persistent into the future. And that's part of the reason they fight these, right? If somebody comes to us with, for example, a hip injury, and they need to replace both hips, okay, that's going to get approved because there's a reasonable recovery period. So long-term disability is where the fight comes in. You have to start the process for short-term as soon as you stop working. And then on the other side of it, you have Social Security disability. You should do it concurrently with long-term disability. Do not wait, because the Social Security Administration really is very slow, and they almost always deny claims initially and forces the person to go through the appeals process. So that process could take years on the government side. No need to delay.
Great. That answered the question perfectly. And one more thing, should patients also be documenting, or their doctors documenting, unsuccessful attempts to remain employed? So showing that they tried to work and they couldn't maintain a job, they were let go or lost that position, or does that not matter as much?
It matters incredibly, because what it speaks to is the person's credibility. They didn't just from one day to the next decide they're going to stop working and stay home and watch reruns of Oprah all day long on TV. That's not what's going on. You have somebody who got up and they're not feeling well and they tried to go to work and it didn't work out. So that becomes a powerful piece of evidence I get to argue that actually, no, it's not subjective. It's not self-reported. It's a person who is trying to persevere and push through. And the attempt to return to work is itself evidence of inability to work.
Excellent. And then I know we're out of time, but I want to ask one more thing. Have you seen, has long COVID changed how disability claims are viewed?
By the insurance companies? I think so. We're now seeing with long COVID more of the claims being approved than initially. When the pandemic just happened and all the long COVID claims were coming up, man, we were just getting an influx of phone calls. They were not paying anybody for long COVID claims. And I think collectively the work that has been done on the medical side, the progress that has been done by all of you, and the work on the legal side, it's really made a massive difference in getting the claims approved. But still, there's a lot of work to be done. We are more now seeing the termination of benefits after initial approval, right? So they will approve, they'll pay, a few years will go by, and now they're starting to target the claims for denial by terminating benefits. Back in the day, the same thing happened with HIV, where the insurance companies were just approving anybody who had HIV because unfortunately they just expected the person wouldn't last very long. So they saw end in sight in how much they'd have to pay. But then when all the medication started to keep people alive, all of a sudden insurance companies started terminating people's benefits. So I think that's kind of the stage we're getting to with long COVID.
That's unfortunate. I know I've seen patients where that's happened, where they get the benefits for a time period, but then it starts being denied. So we still have work to do, right? So
Work to do, yeah.
well, thank you so much, Edward Dabdoub, and everyone who joined today. Don't forget to claim CME credit for attending. And our next session will be on September 1st at 12 p.m. Mountain Time, where we will be discussing the underlying biological abnormalities in long COVID and ME/CFS with Doctors Anthony Komaroff, Lucinda Bateman, and Lily Chu. We hope you can join us next time. See ya. Hope you have a great day.
Thank you, everyone.